Federal court dismisses patent claims for aircraft fault detection. A federal district court in Utah has dismissed patent claims directed to intermittent fault detection, IFD technology for electrical systems in aircrafts. The court determined that the asserted claims are patent-ineligible subject matter under 35 U.S.C. Section 101. The case is Total Quality Systems, Inc. versus Universal Synaptics Corp. As the court noted, military aircraft can suffer from intermittent faults in their electrical systems, which are difficult to duplicate and isolate. To solve this problem, in 1987, Brent and Paul Sorensen invented intermittent fault detection, IFD technology, which forms the basis of the Intermittent Fault Detection and Isolation System, IFDIS. This complex fault detection solution is used by the Air Force, Navy, and other customers to identify the sources of intermittent faults, avoiding the need to replace entire electronic systems. Brothers Brent and Paul founded Universal in 1996 to market and sell their IFD products. Universal owns several patents related to the IFD and the IFDIS. In 2006, Universal began working with Total Quality Systems, TQS, to provide IFDIS services to customers. Universal alleged that TQS improperly used the patented technology claimed in 2 Universal patents to design and manufacture prototype IFDIS test program sets for the Air Force and Navyre. As the court explained, to distinguish patent-ineligible claims of abstract ideas from patent-eligible claims, the Supreme Court has set forth a 2-step framework for determining Section 101 eligibility, known as the Alice Inquiry. At Alice Step 1, the court must decide whether the claims at issue, in their entirety, are directed to ineligible subject matter, such as an abstract idea. If not, the inquiry ends, because the claim is patent eligible. But if the claims are directed to an abstract idea, then the court analyzes the claims, both individually and as an ordered combination, under Alice Step 2 to determine whether they contain an inventive concept sufficient to transform the nature of the claim into a patent-eligible application. TQS argued all 3 claims of the patents at issue are directed to abstract ideas. According to TQS, Claims 1 and 8 of Universal's 475 patent are directed to the abstract idea of detecting electrical signals, and the patent does not provide any specific structure indicating how any of these functions are accomplished. Similarly, according to TQS, Claim 12 of Universal's 826 patent is directed to the abstract idea of mapping connection points using well-known generic technology and storing the results, but provides no algorithm or structure as to how any of the claimed functions or operations are to be performed. The court noted Universal's near-complete failure to address Alice Step 1 and stated that arguments raised in a perfunctory manner are waived. As for Alice Step 2, TQS argued that all 3 claims use generic and conventional prior art items, including inputs, a switching module, outputs, a neural network, a test meter, nodes, pins, and circuits. Said the court, these elements are common in electronics to carry out the abstract idea of providing signals to inputs, monitoring outputs, capturing and/or recording signals in an electrical system. The court found that, because the innovations described in the specifications are not found in the claim language itself, Claim 12 does not satisfy the Alice Step 2 analysis. The takeaway here is that it's important to claim specific technological improvements and to show how they solve problems in the prior art when drafting a patent application. Need to help drafting your patent? Book an appointment with us at www.eonlaw.com. Eon Law. Unleashing Genius.